Thank you, Mr Speaker. I rise to speak on the Victims' Orders Against Violent Offenders Bill and say that the objective of this bill is a very important objective. In fact, I would go as far as saying an essential objective, and we have no objection to it, and that is to protect victims of violent crime and to protect them after the perpetrator of the crime against them has either been convicted and served their sentence if they've been incarcerated, or if they haven't been incarcerated, at least to manage their post-conviction processes. But, Mr Speaker, the problem with this bill is that the way it is being promoted by this government is just totally cynical. And the Honourable Chester Borrows talks about the Invercargill case, which is the case that has prompted this in the first place. But the reality about that Invercargill case, where a rapist was sentenced to a term of 4 years and then post-release harassed and basically made a nuisance of himself towards his victim. In that case, the victim would not be able to avail herself of an order under this bill because the threshold is too high. And when we look at the detail of that particular case and what is in this bill, actually the argument by the government begins to unravel, because it's not only the very high threshold that would apply in relation to victims who might be looking for just this type of protection and assistance. It's the very fact that it is the victim, once again, who has to take the initiative to protect themselves for something that the criminal justice system ought to take responsibility for. The burden falls on the victim. This, yet again, from this government that boasts about, crows about, supporting victims, this is not a victims' rights piece of legislation. This, once again, yet again by this government, puts the burden back on the victim. It re-victimises the victim. And that is the problem with a government that seeks to push sort of red-hot buttons around the electorate, but actually has no real commitment to fixing the problem at all. It is just cynical. Let's go through some of the issues in this legislation. There is the one I've already referred to, which is the cost to the victim. It is the victim that has to meet the cost because it's a civil proceeding. Worse, the victim will have to front up to court to square off against the very person who they are seeking a non-contact order against. That re-victimises the victim again. And then there is the threshold, which requires a 5-year prison sentence, which is just way too high. There are victims of sexual offences and violent offences where the perpetrators don't get sentences of 5 years or more. They get much lesser sentences. But after the completion of the sentence, that perpetrator is equally capable of harassing and intimidating and threatening the victim of their crime as in any other case. Now, why should those victims not have a remedy if this government is serious about victims? And so this bill, Mr Speaker, is totally inadequate. This is, in my short time in Parliament, probably one of the laziest pieces of legislation I've seen. When you look at the regulatory impact statement, it is quite clear that the Ministry and the advisers to the Minister considered a range of options. They considered an amendment to the Harassment Act so that it would apply in these sorts of situations. But the Harassment Act, again, makes it provides for a civil proceeding, a civil application required for an order, a restraining order under that legislation. But the other sensible suggestion that the advisers came up with is an amendment to the Parole Act. And I think one thing they failed, however, to suggest was an accompanying amendment to the Sentencing Act. They argued against or advised against an amendment to the Parole Act on the grounds that they were concerned about uncontrollable cost. The problem with that piece of analysis is when they drew that conclusion, they seem to have forgotten that they expected that there would be about 10 applications for this type of order each year. But they said that they thought there would be a snowballing sort of effect. And I think that could have been dealt with, ameliorated, by putting term limits on the extent of the application with a right to renew on subsequent occasions. But the fundamental point is this. This is a bill that deals with victims of crime, victims of criminals. And the criminal justice system is the part of our judicial system that should take responsibility for managing all aspects of the criminal, not leaving it up to the victim once the criminal justice system has disposed of the offender and washed its hands of it, not leave it up to the victim to have to make applications to further protect themselves. That is the responsibility of the state. That's the responsibility of the criminal justice system. And so, Mr. Speaker, we are saying that the intent of this bill, the objective of it, should be achieved, can be achieved under something like the Parole Act and perhaps the Sentencing Act, but should not be left to the victim to make application for. And so, Mr. Speaker, we will support this bill with these very severe reservations. We will support the bill in its first reading to get it before a select committee so we can hear from advisers and perhaps the Minister to provide some further rationale, but to see if we can come up with a piece of legislation that is a real victims' rights piece of legislation, not the piece of whitewash that we have in front of us at the moment. Because whereas the Minister said in an article, at least in relation to the Invercargill case, at least the Best of Blenheim, when she has the temerity to come out and say that she is sick and tired of hearing from people like the lawyer for the Best of Blenheim and his defences of that sort of that case and the argument for his rights. Well, the Minister, in fact, was quoted as saying, "Frankly, I've had enough of listening to people like the lawyer for the Best of Blenheim worrying about their rights. I'm far more concerned about victims and their rights." Well, that is a piece of bunkum. That is just hocus pocus by probably one of the laziest ministers of justice we've had for a long time. But I want to say this, frankly, I am sick and tired of hearing from a Minister of Justice who does all the window dressing she can, but does not deal with the real issue. And she does it on victims' rights. She does it on other issues as well. She does not care. She does the minimum she can to get away with the appearance of doing something meaningful. But this is not meaningful, as indeed any other piece of legislation that she has been responsible for. I was going to say champion, because she's not a champion of anything apart from herself. But this is a hopeless piece of legislation in its current form. It has good objectives. We should be doing something for victims of violent crime. We should be protecting them. We should be making adjustments to the criminal justice system so that those victims are protected. We should not be putting the burden back on victims so they have to stump up at their cost and front up and face the person who has abused them, has raped them, has violently assaulted them. We should not be putting victims in that situation. We should be providing proper protection. This bill does not do that. So let's get past the hocus pocus and the bunkum and all the window dressing that this government and this Minister of Justice represents, and let's do something meaningful. Let's make the criminal justice system responsible, not only for dealing with offenders who, upon conviction, are then punished and, if necessary, incarcerated and serve their time, but let's make the criminal justice system truly responsible for protecting the victim. And let's come up with a system of orders that will properly protect the victim at the state's cost so that they do not face the threats and intimidation that were exemplified in the case in Invercargill. This bill simply does not do that, and we need, if we are serious in this House's drive and call to provide better protection for victims, then we need to do something way better than this very lazy piece of legislation coming from a very lazy minister. And so, Mr. Speaker, we will support this bill in its first reading. We will get it in front of the Select Committee, and we will pull it apart, and we will hear from officials why they have abandoned their advice to the Minister to amend the Parole Act and to consider the Sentencing Act. And let's see if we can't together, if the National Government is serious, come up with something that will afford proper protection and be a genuine victims' rights piece of legislation.
I call the Honourable Member Scott Simpson.
Thank you.